This lawsuit had engaged in vexatious and unreasonable discovery practices and filed a totally...
Professors would not approve of what Mr. Babiars has done and how he has conducted himself.
All right. Good afternoon. Calling case number 22-008971-CZ in the matter of Rivergate Healthcare Center versus Patricia J. Bouchard.
Counsel appearances for the record.
Your Honor, Corey Phillips, counsel for the plaintiff Rivergate.
Good afternoon, Your Honor. Tony Francis, appearing for Patricia Bouchard. Were you able to hear me?
Yes. Mr. Babiars, you're on mute.
Am I on now, Your Honor?
Yes, you're fine. Thank you.
Good afternoon, Your Honor. Joseph Babiars on behalf of Rivergate Healthcare Center, the plaintiff counter-defendant.
Okay. I have two motions. I have the objection to the 7-day order. Ms. Francis?
Thank you, Your Honor. As I stated in my affidavit, I gave facts surrounding my use of Zoom on July 18th instead of being in person, and I ask the court's discretion and mercy as to the amount. I accept personal responsibility for my appearing by Zoom and not in person on July 18th. I accept whatever amount the court wishes to impose on me in consideration of that affidavit, and then I ask the court to lift the stay and set this matter for trial. I would note, Your Honor, because I think there's some clarification required. There are 3 items that are in the record that I relied on, two of which I relied on, one of which I missed. The first one is the order that was entered by the court on May 13th of this year, in which the sentence ends on the first page with the words, required to appear but does not say in person. That was consistent with my recollection of what was said off the record that day. That if a...
Are you talking about the July 18th date?
Yes, but that date was as the result of an order that was entered on 5/13, or it followed something that was set on an order that was entered on 5/13. And in that order, I'm pointing to the fact that at the end of the first paragraph, this is what I relied on. It didn't say in person. And then I'm also pointing to a first notice of hearing that was filed by brother counsel on Friday, June 14th. Was filed by brother counsel on June 6th of this year, which is the first notice of hearing regarding the motion for stay. And that notice of hearing does not indicate any requirement that it be in person. So the only place where there was a statement on the record in an order or in a notice or in a filing that I'm aware of, Your Honor, and I didn't notice this on that day, is in a renotice of hearing regarding the motion to stay that was filed on 6/14, and that's the one that has in-person underlined, and I missed that on the 18th. On the day I was preparing for the 18th, I missed that. Your Honor, I have been, in this case, I've been diligent. I have been massively injured by brother counsel Babiar's repeated personal attacks, which now include an extensive attack on social media, which I learned about from a third party. I ask for whatever discretion the court might exercise, and I ask the court to consider that after, I also, Your Honor, pulled the transcript from the 18th. I had that transcribed for me. And the transcript itself indicates that Mr. Babiars did not know or did not disclose to the court on that day that the Court of Appeals had denied Rivergate's application. The reason for the motion for stay was because the Court of Appeals had not entered an order on their
Okay,
application.
let's look. You're going a bit further than I wanted to go. Let's deal with
Okay.
first the issue relative to the appearance. I have my settlement conference forms in front of me. I have two of them, and apparently at the April 9th hearing that was via Zoom, I indicated that the next hearing would be in person, and I have it on two settlement conference forms. Where I know at the last hearing, I had indicated that it would be in person. So
Right.
this was what the court had instructed, and then it appears on both of my settlement conference forms, which I have, and that was it. The only thing that the court would consider is a reduction in the amount, but I'll allow Mr. Babiars to respond first, and this is just Mr. Babiars. But I guess, I'm confused in terms of what's your objection? What are you objecting to? The
Your Honor,
7-day order.
yes, because I didn't have an opportunity to make an appearance that day by Zoom as I was trying to, but I didn't. And so I simply wanted an opportunity to express to the court my apologies. I missed it. It wasn't in anything that I looked at. And as my affidavit indicates, Your Honor, I contacted the court. I contacted opposing counsel. I tried to get clarification, and I just missed it, Your Honor. And I'm just throwing myself on the mercy of the court. That amount of an award to me as a solo practitioner is very, very, very harmful to my practice. I am asking the court to exercise its discretion to forgive my error in not appearing by person, but appearing by Zoom.
Mr. Babiar.
Your Honor, as you may recall, Your Honor, this is the case where the counter plaintiff is alleging she was held prisoner at Rivergate Healthcare Center, despite the fact that she was admitted under the person who had the durable power of attorney. It's our contention that this case is a retaliatory, groundless counterclaim. Your Honor, when the court denied our motion for summary disposition and scheduled a court date, we filed an application for leave to appeal to the Michigan Court of Appeals. At the time of the hearing on July 18th, I did not know that afternoon that I was in front of you, the court had denied it. But in the meantime, Your Honor, we have filed a motion for reconsideration before the Michigan Court of Appeals, which is pending. And in the event that's denied, we're going to appeal to the application for leave to the Michigan Supreme Court. And Your Honor, during the course of that hearing, Warren Chambers, the court, you suggested that this matter was better decided by the Court of Appeals in light of the numerous 8 allegations that are all repetitive that allege false imprisonment. But Your Honor, there's no basis for setting aside the stay since we have a motion for reconsideration pending. And if that's denied, we're going to apply to the Supreme Court. But as to the sanctions, Your Honor, Mr. Phillips knew to appear in person. I knew to appear in person. My client knew to appear in person. The only person who didn't know to appear in person was Ms. Francesi and her client. And Your Honor, at that time, I brought a motion to dismiss for her failure to comply with the court's order, and you denied the motion to dismiss, but you said, I'm going to assess costs in the amount of $5,000 to be paid within 30 days. Your Honor, my client has incurred costs of $27,000 in defending this groundless counterclaim, and we think the order should remain. That $5,000, she knew full well. And Your Honor, her excuse, throwing herself at the mercy of the court, you know how often she's done this? Attached to my response, I attached the case of, bear with me 1 minute.
Your Honor, while he's trying to find that, Your Honor.
No, Miss Francie. No, stop.
Attached to my response was Rob versus Moon Lake Property Owners Association, in which a federal court noted that Ms. Francesi had engaged in vexatious and unreasonable discovery practices and filed a totally groundless lawsuit and sanctioned her to the tune of $213,000. Also attached, Your Honor, was the case, a Court of Appeals case Neff versus Chapel Hill, in which the Michigan Court of Appeals found that Ms. Francesi had a pattern of repeatedly violating court orders. Now she's standing before you all humble. Oh, Your Honor, I beg for mercy. This is part of her MO, Your Honor. And she knew full well, or should have known, that she had to appear in person, because my second notice of hearing was in bold print, and your notice of hearing dated in April said in person. So there's no basis for her failure to do that, Your Honor. And I would ask that the sanctions remain in place and that you deny her motion to lift the stay. I would also add, Your Honor, that the order for stay proceedings was entered that day, and there's no basis for a motion to lift stay. Procedurally, she should have filed a motion for reconsideration because she's not entitled to a hearing. Same with her objections, Your Honor. The order that I prepared on the sanctions comported with your ruling to the letter. If she didn't like that, the proper procedure was a motion for reconsideration, but she's not entitled to a hearing on a motion to lift the stay because procedurally all she's entitled to was a motion for reconsideration. But in any event, Your Honor, I'd ask that you would continue enter the order or maintain the order for stay of proceedings and enter the order for sanctions.
Your Honor, if I
Mr.
may,
President.
yeah, just really quickly, Your Honor. Brother counsel claims that he came to you and appeared in person on July 18th, and for whatever reason did not let you know on the record that the Court of Appeals had denied the motion that he filed, the application that they filed in the Court of Appeals. So he stood before you.
I didn't know you.
Hold on,
Whoa, let me
Mr.
finish.
Mr.
Let me
Babiar, hold
finish,
on.
please, counsel.
Go ahead.
For
Talk to
whatever
me.
reason, Your Honor, thank you. For whatever
Mhm.
reason, Mr. Babiars was before you 2 hours after notice was given by the Court of Appeals that his had been denied. Not only that, Your Honor, 6 days went by between the time he stood before you and didn't tell you, and 6 more days went by between that time and the time that the court entered the order on July 24th. And Mr. Babiars filed nothing, did nothing to advise the court that what he said on July 18th was no longer true, was not truthful. Not only that, Your Honor, but I've now looked and read the transcript from the 18th of July, and I've read the application that was filed in the Court of Appeals, not the application, I'm sorry, the motion for reconsideration. There are material misstatements in both, in the motion for reconsideration in the Court of Appeals by Mr. Babiars. There's nothing in the transcript that says what he says it said.
Okay, but that's not properly before me at this time.
I understand.
Your Honor, when I was before you on July 18th, that afternoon, an email had come to my computer here at work. I had no access to that, Your Honor, and I had no idea that the Court of Appeals had rejected our application till I got back from court that afternoon. And Your Honor, as far as not telling you, Your Honor, it's my understanding from our chief appellate attorney that the Court of Appeals would have received that same notification. So there was no reason for me to notify you since the Court of Appeals was notifying you. But in any event, Your Honor, we have filed a motion for reconsideration. And if the Court of Appeals denies it, we're going to the Supreme Court. And as you yourself suggested, Your Honor, this case might be better decided by the Court of Appeals. But anyway, Your Honor, again, I'd ask that the order that her motion to set aside this stay be denied, and that the order for sanctions be entered. And again, Your Honor, I would urge the court to read the Moon case and the Neff case to see the kind of shenanigans that this lawyer, Ms. Francesi, has been pulling for years.
Your Honor, Mr. Babiars and I graduated from the same law school. We graduated apparently within a year of each other. I can assure you that the professors that apparently both of us studied under would not approve of what Mr. Babiars has done and how he has conducted himself in this case, Your Honor. He has repeatedly violated the court rules and then projected those violations on me. That's not fair, Your Honor. And
Your
now
Honor,
he has,
Hold on.
no. And now, Your Honor, another thing. This case, and the court has found this case is a negligence case, no matter how Mr. Babbyards wishes to twist the facts. This is a negligence case, a nursing home negligence case.
Your Honor, the
Yes.
fact is that though we went to the same law school, I'm not the one who's been sanctioned $213,000 by the federal court, and I'm not the one that the Court of Appeals has found repeatedly violates court orders. That person would be Ms. Francesi.
Okay, and in terms of Ms. Francesi, I think that you went about this in the wrong way in terms of your objections, because there's nothing objectionable in the order except as to the amount that was assessed. So you, in terms of requesting relief from the amount?
Your Honor, if I knew at the time that I filed it that Mr. Babbyards had been notified by the Court of Appeals, I think that's a reason to object, because the court did not have all the relevant information at the time the decision was made. Even so, if that's the case, Your Honor, I apologize for that, but if the court is going to sanction me $5,000, I will accept that. I will pay it. But Your Honor, that I'm asking the court to reconsider. There are a lot of problems with the way Mr. Babbyards has procedurally engaged in this matter.
What I'll do is I'll reduce it. I'm not going to remove it, but I will reduce it. I'll reduce it to $2,500.
Thank you, Your Honor. I appreciate that.
And you need to submit an order to the court indicating that the sanction has been reduced. You need to present that.
I will, Your Honor.
And Your Honor, will that be payable within 30 days of today's date?
Yes, 30 days.
Your Honor, one more thing regarding the stay. The Court of Appeals has put it up on the docket on August 20th of this year. August 20th, the motion for reconsideration has been put up on the administrative reconsideration docket. So
August the 20th?
On August the 20th.
They put it on.
Put it up on the,
but it hasn't been scheduled.
That's correct.
Okay, well, at this time, I'm going to deny the request to lift the stay. And, granted, the court does get, but the court has over 900 cases, and, the onus is still upon counsel to alert the court when the decision comes down. So I'm going to continue to stay until further order of the court. And it'll be, the impetus is upon the counsel to alert the court. And the court doesn't find that, due to the fact that, Mr. Babbyards was in court that day and the order came out 2 hours early, that it was expected that he would know about it, within that time frame. So the court isn't going to entertain that, because it's still reasonable that if he had to prepare and come to court, that if it came out 2 hours beforehand, that he would necessarily be required to have that knowledge within a couple of hours. So that's a non-issue to the court at this point in time, and we'll continue the stay as it is in place. And let me check to see if Ms. Clifton has a review date, because sometimes she'll put a review date if there's a stay. We don't have a review date, but what I'll do is, and this isn't a date you will have to appear. Ms. Clifton will just reach out to you to make a determination if the Court of Appeals has done anything. We'll put a review date October the 14th. And of course, if you hear something prior to that date, please alert the court.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, thank you. I'll look for those orders to be submitted.
Thank you.
Have a nice weekend, Your Honor.
Thank you. You as well. Take care.
Thank you.
Thank you, Your Honor.